Okay. Well, good afternoon, everybody, and welcome to our program, Mediation Skills and Training for Litigators. I am your co-chair today, and I will be sharing my chair position with Donny Satani. I am a UK lawyer. I've been litigating in the UK for about 10 years or so, and in Ontario, I am a mediator. My area of practice is civil and commercial law with a specialization in MVA and medical malpractice cases. Our program today is part one of a two-part series. We have a great faculty with a wealth of experience today to share their best practices on today's topic, which is preparing for mediation. Before we get started, I do want to thank Saba for organising this for us, especially to Jasmine and Amandeep, who have been integral to helping us get this off the road. And a little bit of housekeeping. We are here until 2:30 p.m. We will be having a question and answer session, which will start around 10 minutes past 2. If you have any questions or comments throughout the panel sessions, then please do write them down in the question and answer box. And either Donny or I will get to them when the Q&A session starts. If you would please have your mics and your cameras off, that would be great. But if you want to speak your question during the Q&A session, please do so. And we'd be more than happy to unmute you. And with that, I'm going to hand it over to Donny to introduce the speakers to us today.
Super. Thanks, Afsana, and hello to everyone, and thank you for joining us. My name is Donny Sirtani, and like Afsana, I've also first trained in England and practiced there for many years before moving to Ontario. I'm now a dual English and Ontario qualified barrister, and I have an independent arbitrator and mediator practice focusing on commercial and financial disputes. I used to be an accountant, so that's my excuse anyway. And I'm delighted to introduce the other two speakers who are joining us for today's session. Mitchell Rose is a senior mediator and counsel based in Toronto. He's a chartered mediator and a fellow of the International Academy of Mediators and brings decades of litigation and ADR experience to the panel, including some 13 years as a neutral. And his practice encompasses a broad range of dispute types, including employment, commercial, real estate, and more. So thanks so much for joining us, Mitch.
Thank you.
And I'm also really pleased to introduce Amandeep Dhillon, a partner at the boutique litigation firm Kramer Simon Dillon LLP. He has a decade and a half of experience in handling all kinds of civil, corporate, and commercial litigation, including extensive use of ADR to help meet his clients' needs and objectives. And so thank you, Amandeep, for making time to be with us today.
Thank you.
Right, so we've got lots to get through in today's program, and I'm keen to get into it. As Afsana explained, today's theme is about preparing for the mediation day, while our session next week is about the mediation day itself. So for today, our running order is as follows. First, Mitch will talk us through when in the life cycle of a case we should think about mediation and related questions about getting a mediation set up. And then we'll hear from Afsana about selecting a mediator, including consideration of EDI issues when doing so. Thirdly, I'll say a few words about writing an effective mediation paper. And then to wrap up the session, Amandeep will help us to think about how to prepare our clients for the mediation. And so with that as an overview, Mitch and Afsana, can I hand over to you?
Absolutely. So Mitch, I'm going to kick off with a question. When is it considered a good time to think about mediation in the life cycle of a case?
Well, I'd say that any time is a good time. My personal bias might be showing there, but certainly in most cases, or majority of cases, there are some times that may appear better than others, and there's certain factors that I think counsel should pay attention to. So I'll touch on some of those in order to answer your question. First thing is, I think even before there's litigation, is to consider whether or not there's a contract that requires mediation to take place at any particular stage of a dispute, in particular prior to litigation. Often those provisions in a contract will require mediation then combined with arbitration, not mediation arbitration or MEDAR, but for mediation to take place. Now, this used to be relatively straightforward. It's not so much anymore because of the recent Supreme Court of Canada decision that was released in the summer in the Uber and Heller matter. And so now, we have to give consideration as to whether or not the mediation clause in the contract is actually enforceable. It could be unenforceable due to unconscionability. I'm not going to get into the details of the court's decision, but it's just something to consider as well. If it's an employment contract or a gig economy type job agreement, such as the Uber situation, there are some other considerations, including whether or not the provisions void under the Employment Standards Act. So lots to consider there, but pay attention to contracts first of all. The second thing to consider is whether you want a mediation to take place early or not in reference to the Limitations Act. And I'll just briefly explain what I mean. And by the way, a lot of these authorities that I'll be referring to are found within a paper that I've submitted and that everyone should have. It's the first 10 tips of my 40 mediation advocacy tips ebook, and you can get the rest of the tips by having a look at what I've submitted, and there's a link in there for that. So you don't have to worry about copying down names of cases quickly or anything like that. But essentially, a limitation period under the Limitations Act, a basic limitation period, can be suspended by simply agreeing to mediate, and that doesn't require actually having to enter into a formal mediation agreement. That could just simply be an email that between you and the other lawyer that says, hey, let's mediate. So that's something to pay attention to. The authority for that, by the way, is a Court of Appeal decision called Sandro Steele, and I think it's pronounced Chisa or Kisa. And then I think what's probably better known by everyone is whether or not the mandatory mediation provisions apply if an action of an application has actually been commenced in Ontario. And so, of course, it's important to have a look at rules 24.1, which deal with civil matters, and 75.1 if you're dealing with an estates matter. The other thing that I think is important to bear in mind, regardless of what the time, the restrictions on time that are set out within those rules, as well as any practice directions, local practice directions, is I think it's important just to determine whether or not you still want the mediation earlier or later. And that's going to depend on a host of factors, because there's some leeway within those rules if you take a look at them. In general, I'd say the earlier, the better in terms of holding a mediation. In the majority of cases, not all, even if it doesn't lead to a full and final settlement, you could end up with something of value. You can narrow issues. You can end up getting a sneak preview of witnesses potentially, at least if there's a joint session, you get to understand the other side a little bit better. And then the other thing to just consider in terms of holding it early is you could potentially save a lot of cost. And I go into this in my paper. I talk about the sunk cost fallacy. And the more you spend in terms of time and emotion and money, of course, the harder it is then to walk away from that investment as time goes on. So earlier the better, even though in certain areas of the law, the practice is to hold mediations after discovery. For example, insurance, personal injury cases are well known for that. And in employment cases, for example, the trend is to hold the mediations as early as possible, sometimes even pre-litigation, at least within the GTA. So those are just some considerations, but to go back to what I originally answered with was, I think just any time is a good time to consider settlement, and you don't need to have just one mediation. Mediations can continue if they don't result in a settlement after the first, say, 3 to 6 hours. A lot of mediators will work with you by email or by telephone afterwards. And so it's possible a mediation could last for some time. And it's just something that you should always think about, even right up to the day of trial, beyond the pretrial stage. That's my long-winded answer to your question, Afsana.
Thanks, Mitch. Here's something. The mediation world was hit by a little storm called the COVID-19 pandemic earlier this year. And we were all kind of a little bit affected by how that took on mediations going forward. So speaking now in November, after 6 or 7 months of living with the pandemic, how has the COVID-19 climate affected clients' appetite to mediate, and lawyers for that matter?
Yes, and what I've observed is 3, say, phases since we were locked down back in mid-March. Initially, what I found was there was this, people embraced holding mediations virtually, such that, in my experience, the mediations that were already scheduled to be held in person, ones I was scheduled to mediate or was involved in as counsel, they proceeded by way of Zoom. A lot of mediators got up to speed quickly. Counsel were open to it as well. Some of them proceeded just by telephone, but they took place, and I wasn't seeing widespread cancellations. We then entered phase 2, where things got very quiet, and both my mediator and my litigator clients have told me, and so we're talking about May, June, July, where I think people were taking a wait and see approach with respect to whether mediation was necessary. I think plaintiffs counsel were always eager to mediate if the possibility or the possibility was there. But we did see some hesitation on the part of defendants and defense counsel for a lot of reasons. We didn't know when the courts were going to become operational again. There are, of course, fiscal concerns as a result of the pandemic. And then now we've, I think, entered into phase 3, where there's been a general acceptance in what I've seen is a general acceptance that, okay, we need to forge on. And mediations will now take place exclusively, if not for the most part, virtually, and whether they're by way of Zoom or Teams or some other platform. I think people are not hesitating going to mediation anymore, and they're just carrying on. There are possibilities to hold. It is possible to have an in-person mediation or a hybrid mediation where it's partially in person and partially by way of video conference. So those are popular. It also depends on the region of the province that we're talking about. So I know within the Greater Toronto area, in-person mediations are not particularly common. I conducted one in the summertime in downtown Toronto, but I haven't been consulted about any of them. But if you go to places further outside the GTA, you'll find that in-person mediations may be more popular. So that's more or less what I'm seeing. And what I do think, though, is, once we're out of this pandemic, whenever that might be, hopefully sooner than later, I don't think we'll see a return to what we had prior to 2020, whereas virtual mediations were really the rare exception. I think they will now become the norm, but we will still have a healthy amount of, hopefully a healthy amount, because we can only do it if it's safe, a healthy amount of in-person mediations and hybrid mediations.
Thanks, Mitch. And then I want to talk a little bit about what happens when parties don't agree on mediating. So what can you do if a client or an opposing counsel refuses to participate in a mediation?
Yes, and you know, this can be an issue even if the mediation is mandatory, because you can get into timing issues. As I mentioned before, there's a lot of leeway within the rules in terms of when the mediation actually has to take place. But let's to simplify things, let's approach this as if mediation is not mandatory. It's purely voluntary. So I think there's a few things that clients and opposing counsel should be made aware of if they are skeptical about mediation or just absolutely refusing. So the first thing I think as lawyers that we need to pay attention to is a little known rule of professional conduct of the Law Society, which is 3.2-4 or -4, which is the rule about encouraging compromise or settlement. And that rule simply says a lawyer shall advise and encourage the client to compromise or settle a dispute whenever it's possible to do so on a reasonable basis, and shall discourage the client from commencing or continuing useless legal proceedings. Even more important, though, I think, is commentary 1, which states it's important to consider the use of alternative dispute resolution, ADR. When appropriate, the lawyer should inform the client of ADR options, and if so instructed, take steps to pursue those options. So I think mentioning that to your client and also just mentioning to your friend the professional, reminding them politely about the professional obligations they're bound by, I think is important. It's really, I think it would be very difficult to argue that ADR is not appropriate, or mediation in particular is not appropriate during a pandemic. But I think in general, it's always appropriate, but rarely inappropriate, unless we're talking about family law proceedings, which I'm not, because they have special considerations, as some of us may know. So I'm referring to civil and estates cases. The other thing to bear in mind, particularly these times, is the fact that Chief Justice Morowitz of the Superior Court on May 18th, 2020, has written the following, and this was in a consolidated notice to the profession effective May 18th, 2020. The court calls upon the cooperation of counsel and parties to engage in every effort to resolve matters for civil proceedings. This includes attendance at mediation, whether prescribed or not, where a mediator is willing to engage in a virtual mediation. Lots of us willing to engage. So we have the Chief Justice of the province encouraging us to engage in virtual mediation. How to enforce that? Well, that remains to be seen. I haven't found any case law on point. However, I wouldn't want to be on the receiving end of that. But I could see how the court might penalize a party through costs by failing to engage in a virtual mediation. The last thing I just want to touch on, which I think is actually probably the most convincing reason, especially if you have counsel who are against mediation. And I think it's also applicable even if we're not in a pandemic. And that is, there could be cost consequences for not engaging in mediation, even if it's not mandatory. And the authority for that is from 2018. It's a Superior Court decision called Canfield and Brockville, Ontario Speedway. I'm not going to bore everyone with the facts. It's a very lengthy decision. The part of the decision I'm referring to is a decision on costs. And in a nutshell, it says if there's not really a good reason to refuse mediation, and if you read the case, you'll see that there are very few situations where there would be a good reason. This was a personal injury matter. Then yeah, you could be penalized in costs if you're the party that has refused to engage in a mediation, regardless of the prospects of settlement. So I think those three things together, rules of professional conduct, what the Chief Justice has to say, and potential cost consequences as a result of the Canfield decision are all good reasons why we should be telling our clients you should mediate, and you should mediate virtually, as well as explaining to our friends who are opposing it. The other thing, just to sneak in there, and I think it's just important, is consider mediating small claims court actions. I know it's not mandatory. I know that we can now have settlement conferences by way of video conference, but settlement conferences are not mediations. We don't have the time. They're not set up as mediations. The judges conducting them aren't necessarily trained as mediators. And good luck trying to get a trial. And so using this time effectively, I think, is particularly in a case that's $20,000 or more, this is really a good time to think outside the box and consider attending a mediation, particularly if the other side is represented by a lawyer or a paralegal. And those are my reasons. Those are my submissions. Thanks,
Mitch. That's really helpful. And yeah, I completely agree with the small claims court. Trying to mediate those, there's going to be such an enormous backlog following the pandemic. I'm always advising clients, just to get onto those and start, getting into mediation, because I think there's a few mediators out there that will give you kind of better rates as well, right? So yes, it's always worth chancing it.
Yeah, I think it's worth it, especially if you can't move your case ahead. Yeah, it's just going to sit there. Then yes, definitely. It's probably money and time well spent.
Yeah. Thank you very much, Mitch.
Thank you.
Super, and many thanks both. Okay, and I think that then takes us to our next segment, which looks at mediator selection and a discussion of EDI considerations. So Afsana has real expertise in this matter, and I'm really pleased that we've got this opportunity to hear from her. Her slides have been circulated, so you can refer to them at your leisure. But now we just get to throw some questions at you, Afsana. So if we start maybe by asking, what are some of the issues that lawyers should be taking into consideration when selecting a mediator?
Okay, well, Donnie, that's one of the questions I asked myself earlier on in my career, and I wondered what it is that a lot of the mediators look at, or the lawyers look at, when they're selecting a mediator. So I started a study just before the pandemic came crashing down on us all. And I asked a handful of Ontario lawyers, what are their key considerations when they're selecting their mediator? And I've included this in my materials, so you can have a look in there. But the most popular thing that lawyers take into consideration is the expertise of that particular mediator. And then it comes down to complexity, how complex the case is, and how many parties are involved. And then the third one was approach, which came in at 58%. So I should actually say properly that the expertise part, 83% said that was the most important thing. And then 75% said complexity, 58 said approach, and then reputation matters to 50% of those lawyers as well. What is their reputation around the legal society? Availability was 33%, and the diversity of the mediator, which included anyone from a BIPOC or disability, any other marginalized, or even women, was only 25%. So it was quite intriguing to listen to the lawyers, and sometimes I felt as though they mentioned, diversity-related answers because I was a diverse person asking them. So I don't know whether it was a bit of tokenism thrown in there or not, but it was quite stark, the information that I received. And, there's no doubt that, those expertise and complexity and the approach and so on and so forth actually matter in a mediation. Those are the things that, we should be looking out for. But something happened in the mediation culture in that there are the people who have seniority in the profession tend to be much older and tend to be of a particular demographic that often don't have diverse mediators. So it became a bit of a problem when it came to some of the rules of professional conduct that we need to adhere to, especially within integrity, and some of the commentaries there where we have a duty and a responsibility to accommodate our clients. So I looked into accommodation and what that really meant. And it is that we need to make sure that our clients feel comfortable with the person that they're mediating with, and that they feel that they are being represented. So I had a look at the census statistics as well, and it revealed that actually 51% of Torontonians are actually a visible ethnic minority. So that's more than half of the population in Toronto. And in Ontario overall, it's 29% visible ethnic minorities, which is yet set to grow again over the next 10 years or so. So it's kind of a stark statistic to look at. And then when you look at the representation within the mediation profession and the fact that diverse mediators are underrepresented. And so it comes back to how we select a mediator that is that really accommodates the client. So some of the things that we need to look at is really the audience themselves. Is that what does the client want? Who does the client want to help them mediate? Does the client have a particularly diverse background themselves? Do they have poorer English that maybe they feel more comfortable speaking English with somebody who they feel represents them? Are there any cultural sensitivities we need to adhere to? You know, all these like different elements of your audience should inspire you to be more selective when you're thinking of mediators. Just really thinking about how you can include diverse mediators within your profession as well, because as the diverse population continues to grow in Toronto, there's going to be more of a need for diverse representation as well.
Super. Thanks, Afsana. And certainly based in my own experience, I can endorse that fully, the idea that actually clients feel comfortable with the mediator that they can feel a rapport with, and that can contribute to effectiveness.
Yeah.
But based on what you said about how mediators are currently selected, or at least what survey respondents are saying are the criteria by which they select mediators, what can you recommend to ensure inclusivity and perhaps to sort of help make a change for the better?
Yeah, so there are lots of things that we can do, Donnie. The most important thing is actually looking at your own cultural competency as well, and thinking about, as I said earlier, you know, what the client needs. And often most lawyers will have a preferred list of mediators where they use the same mediators over and over again. You know, they have their set list of 3. And what can often happen is that those 3 mediators may not fit well with the other side. So how do you go on from there? It's a tough thing to ensure that your list is current in a way that it fits in with who you would like to mediate with, as well as who your client and the opposing counsel would like to mediate with. So having a diverse list of mediators is highly recommended. You know, you need to have women on there, you need to have colored women, colored men, younger, older, disabled. You know, really mediation isn't all about having the niche in the market, having the expertise in the market, is also having the ability to communicate well. And I'll give a quick example here is that, you know, I've been a litigator in the UK for some time now, and I'm very well adversed with, you know, personal injury law in particular. Yet when I was in a mediation with two different parties, one of whom was Polish and the other was Russian, I was stuck between two cultures that I didn't really know that well. With the Polish culture, you know, there was a bit of European there, so there was a bit more of a rapport, but I didn't quite know how to break down the conversation with my Russian client. And so it built up a barrier that in the end, you know, I couldn't really tear down. And I wondered whether if I had, this was a small claim, so it was kind of thrust upon me, so I didn't know the parties very well, or before I went into the mediation. So it came as a bit of a surprise, but understanding what my own cultural competency is and how well adverse I am with certain cultures is incredibly important. There are over 200 different cultures in Canada. That in itself is an overwhelming statistic, and there's no way that all of us are going to learn, you know, 200 different cultures, but being aware of it and finding some way to communicate and having those people on your list to help you through a mediation is always going to help break down impasse. And I also would recommend that lawyers try different mediators. So a good rotation is always going to be helpful. I've heard from the legal society that, you know, people tend to get comfortable with certain mediators because they know it works and they know that, you know, they will succeed in the mediation, whatever the reason is for having that one mediator. But what it in actual fact does is create a closed network of mediators, not allowing people from diverse backgrounds or men and women to come into the profession. So opening up your ideas in terms of rotating through different mediators, whether you've mediated with them or not, is possibly a brave thing for you to do because it's not something you've done before, but it's definitely more inclusive. And if you feel that way, if you feel that you're not quite brave enough, the best thing to do is to pick up the phone and give that mediator a call and talk to them. I mean, that will help break down any biases and any stereotypical views or anything other, you know, to help you along.
Super, those are some great tips, Afsana, thanks. I'm sure the audience will take that on board. And then finally, what are some of the challenges in selecting a mediator that's really right for you and your client?
So I was speaking to a colleague not so long ago where she was saying that, you know, she had her list of mediators, and it was a client who was saying that, you know, that the client had a specific idea of what type of mediator they wanted. And, you know, as well as knowing what kind of mediator the client wants, you've also got the opposing party who needs to agree to the mediator as well. With all the different parties involved, it can get quite difficult to pin down the right mediator. Now, some of the interesting conversations that I've had in the past is, you know, I wanted to have a woman mediate my case, but my opposing party didn't want to for X, Y, and Z, or I wanted to have a diverse mediator because I would have thought it helped my client, but the opposing party said no. So those challenges are real and they exist. I was on another panel with another ADR institution a few days ago, and the question was, you know, what does happen if the opposing counsel says that choosing a diverse mediator for your diverse client means that there'll be no neutrality in the mediation, and what my response to that is, well, you know, some of the audience really answered the question themselves, is that nobody is 100% neutral, but in a professional setting where one party is wanting a diverse mediator, but the other side feels that no, the challenge is too high, and then the mediator will perhaps start leaning toward one side more than the other. Those challenges can often be real and really throw some barriers in the way of succeeding in a mediation. So some of the things that I would recommend is if you come across a situation where your client is diverse and they would like a more diverse mediator to help you through, the other party should be contacting your recommended mediator and speaking to them and interviewing them and really seeing how it is that that mediator can help both sides, not your side, but both sides, come to an agreement that will eventually help you settle the case. And speaking to, again, as I said earlier, speaking to that mediator will help you release some of those biases that you may have had for no reason. And then, some things that lawyers often do is perhaps even have two mediators there. One of each party's preferred mediator, but that can kind of get expensive, and it's also if the mediators don't get along or don't agree on how the mediation should proceed, it can get a little bit complicated. So if you are to have two mediators in the room, you have to ensure that there is that synergy there between all of the parties, and the expenses can be covered as well. And again, remaining neutral is the absolute utmost importance in a mediation, and despite some of our own personal views, those personal views don't often come out into a mediation. So mediators' jobs are to remain neutral as much as possible. And if you feel that there is a problem, then caucusing or speaking to the mediator to regain balance in the room are always good things to do. Yeah. So if there are challenges, my first and foremost is look at those challenges, break them down. What are the other side? What are they saying? Why do they not want the mediator that you have selected? Really explore the reasons. And if that one mediator doesn't work, then find somebody who is in between the both of you, and both of you can agree, but with the needs of the individual clients. They're the most important thing here. They need to have a personal conversation with the mediator. They need to feel comfortable to be able to have their say.
Yeah. Super. Thanks so much, Afsana.
No worries. There is a question actually, Donnie, on there asking whether this counts towards CPD and EDI professionalism hours. I know that I said that I'd address questions later on, but I've got a few minutes here. So the Law Society has gotten our application, but unfortunately they've been overwhelmed with applications toward the end of the year for EDI professionalism hours. So we will let you know in the days coming in professionalism hours. So thanks for that.
Super. Thanks so much, Afsana.
You're welcome.
Great. And so that then takes us to our next segment, in which I'll talk to you about writing an effective mediation paper. Let me just put up a few slides. And so I thought I'd start by talking through a few points with the help of these slides, which have also been circulated, and then we can do some Q&A after that. I think I'd like to start just by saying, in my practice, it's fair to say I've seen a great deal of variety in mediation papers or submissions, and I've had to write quite a few. And the thing that struck me about the less effective mediation papers is that they have felt to me to be a little bit formulaic. A mediation paper should probably be less formulaic than other forms of legal writing. And if you looked at some of the papers that I've written in the past, they tend to look a fair bit different from one another. And so if there is no standard formula, well, what could I tell you today that could be useful? Well, I think I'd like to start with these 4 points to bear in mind, even before you put pen to paper in drafting your mediation paper. First, think carefully about who you're writing for, who is your audience, and what is your purpose? What are you trying to achieve with your audience? I'll drill down into this a little bit more, so let's park this one for now and move on. The second point I think I'd like to draw out is this the kind of case where a pleading or factum style approach will help me in my mediation paper? Will it really add anything? Now here I would say it does vary from case to case. Each case is different. But broadly speaking, if you are mediating at a relatively early stage, then it may be beneficial for the other side to see how coherent your case looks in a legal form. But if you're mediating at a relatively late stage and you've already exchanged pleadings and perhaps some written arguments in relation to some hearings, then the other side have already seen and heard it. And so your mediation paper is a valuable piece of real estate. And so you don't want to waste it with repetition. The third point I've got on the slide borrows a little bit from one of the best creative writing teachers I ever knew, which is show not tell. If you want your opponent to worry about what might happen at trial, so let's say in your mediation paper, you want your opponent to be thinking about the risk that they might be found to be either dishonest or negligent or something of the sort. Well, there's no point name calling. Your client might be impressed if you write a really vitriolic paragraph full of adjectives, but everyone else is just going to see it as bare partisanship. It's not really going to persuade anybody. If you want to make your point more effective, you might want to identify a handful of objective facts and lay them out. So for example, your paper might say, the defendant will need to explain at trial why it is that he wrote X in his email to my client, but on the same day wrote Y in his email to his business partner, or whatever it is. A much more sort of temperate presentation where you show the problem that the other side has is probably going to be more persuasive than name calling. And then finally, in a similar vein, be wary of antagonizing your opponent with your mediation paper. If this case gets to trial, you're going to want to persuade the judge. And at that stage, as long as you stay within ethical boundaries, it doesn't matter if your opponent gets irritated at you or upset at you. But in a mediation, your client and your opponent ultimately need to come together to reach a deal. So here, doing the best for your client means that you need to make your opponent, of course, understand their litigation risk, but it's actually counterproductive for your client if you aggravate your opponent and make a deal less likely. Because in traditional litigation, it's your client versus your opponent. But in a mediation, it's your client and your opponent on one side versus the dispute on the other side. And so really, you want to obviously put your client's case well, but you want to facilitate your client and your opponent working together. So those are all things that you might want to bear in mind when you are starting to put together your mediation paper. So now let's go into that first point a little deeper. When you're writing your paper, who are your audience and what are your objectives? Well, you can see what's on the slide, but in short, a mediation paper can have multiple audiences. Formally, the paper might be addressed to the mediator. Now, the mediator is not going to adjudicate your case, but you will still want to make a good impression on them because you will want them to go into the other side's caucus room and effectively to be able to say that your case looks credible and coherent. But you also want to give them the tools that they'll need to try to find a settlement. And I'll say more about that in a few moments. But let's think a little bit about the other audience members as well. You are writing with opposing counsel and the opposing client in mind. And it's worth remembering that this mediation paper may be the only document you write that the other side's client actually reads. They may not actually read your pleadings, they may not read your factums, but if you write this paper well, you can hope that they will actually read it. And so you want to make it easy to read and accessible. So what might you want to do? Well, you'll want to present your case well, of course. And you might also want to bring up points that you want the other side's lawyer to discuss with their client and find a way to flag it here. So maybe you are concerned that the other side hasn't really discussed with their client the risk of adverse costs. Or maybe in a corporate dispute, there's an issue about a parent company guarantee that you think hasn't had enough attention, or a key piece of evidence. If you put it in the right place in your mediation paper, you can effectively put it on the agenda for your opposing counsel to discuss with their client. On the other hand, if this is the kind of case where you think that the mediation might be able to result in a future business relationship, then you might want to think about how to signal that. If the other side's client comes into the mediation thinking it's going to be scorched earth, then it's going to be quite difficult to negotiate that. On the other hand, if they come in keen to make peace because they want to move on to a new business relationship, then you can change the whole mood music of the mediation with the way you write the paper. And another key audience is, of course, your own client. You might have thought really carefully about how best to position your client in the mediation. But if your client is not well prepared, then your messaging doesn't really work. So working with your client in drafting the mediation paper will mean that they are across all the points they need to be, and you and your own client are on the same hymn sheet. And a purely legalistic mediation paper is unlikely to achieve that. A well-written discursive paper can do the job better. So going back to the point in a little more detail about, well, what do I need to give the mediator in the mediation paper? What does he or she need? Well, as we've already discussed, even though they're not adjudicating your case, they do need to see a presentation of the merits so that, if necessary, they can speak up for your client in private sessions with the other side. They can say to the other side, you know, isn't there a risk on issue X or issue Y? They will also potentially need financial information about the case. Some of the most frustrating mediation papers that I've seen are littered with arguments, but with no indication of the financial impact of the argument. Sometimes it's clear because an argument might be that if a particular point succeeds, it will defeat an entire claim, but often that's not the case. And so if, for example, you're arguing for a partial limitation defense, it's important for the mediator to know whether that defense takes off 10% of the claim or 50%. And similarly, if you are arguing contributory negligence, then you should be thinking about putting forward a figure for what discount you say the court is most likely to apply. The mediator will need those sorts of numbers in order to try to broker a deal. They'll also need costs information. What are your future costs? What costs can each side save by settling now rather than fighting to trial? But also, what about the past costs? The past costs are sunk costs, and so in that sense are irrelevant to a decision about settling. But they are useful for trying to estimate what sort of adverse cost orders might be made at trial. And then there are other settlement drivers that the mediator might find useful to know about. They might want to know what offers have been made in the past, whether there is insurance or funding in place. You know, a plaintiff might want to use these as a show of strength to show that it can fight the case all the way if needs be. But a defendant might also be encouraged not to settle if there is insurance in place, because they will know that if there is a costs order in their favor, they could actually get paid. If there are reputational issues to be considered, they can also be flagged, although one needs to be careful to flag them appropriately and not make baseless threats against someone's reputation. You might also want to think about impact on each side's employees, how much of a distraction the litigation will be on business needs, etc. And also what future business opportunities there are. If the dispute was cleared up, what avenues would open up for future business? And with all of these points, actually, one thing that is worth thinking about is, do you want to put these points in a private note to the mediator rather than the mediation paper itself? Remember, this is not an arbitration, and so there is no problem in a mediation with making a private submission to the mediator that you want only the mediator to see. It's really then a strategic question as to what you also want to be visible to the other side. And then finally, I just thought I might sort of flag a few other points to ponder. With all of these, there is no one size fits all, but here are things that you might think about when you're drafting your paper. So should I include my best points? You know, if you have in the course of discovery found some smoking gun documents, you might be tempted to hold these back for trial, not to put them into your mediation paper, because if the dispute doesn't settle, you don't want the opposing party to have had advance notice of them. And you might think, actually, I can use this most effectively if I take the witness by surprise at trial. But it's worth thinking carefully about whether you really need to do that, because the best smoking gun documents are often difficult to deal with, even if the witness knows they're coming. Indeed, sometimes the fact that the witness knows they're coming can affect them in the witness box anyway. And if you put your best cards on the table in the mediation, you give yourself the best chance of achieving a deal. If you let the mediator know exactly what your strengths are in the case, then your mediator is best equipped when they go into the other side's room to try and make some progress on your behalf. But if you really don't want to share your best material with the other side, there is a middle ground. Again, as I'd said, as with a private paper to the mediator, you might want to share these sorts of documents with the mediator in confidence. And you might want to discuss with the mediator how to get the best effect out of them at the mediation without really giving away the point earlier than you want to. Another question to think about is, should you include an offer in the mediation paper? Some people would say it's generally too early to make a first move before the mediation even starts. But again, I don't think there's a one size fits all. In the right case, it can be a good way to project confidence. You can get the ball rolling and avoid delay at the start of the day. And there's also a lot of psychological research about the effect of anchoring. If you can put a figure out there, you can start to anchor expectations around it. So for example, if you're the defendant in a $10 million claim and you make an offer of, say, $600,000 in advance of the mediation day, then your opponent will have a few days to get used to the idea that maybe that's the right ballpark for their claim. Whereas if you let them make the first offer, and let's say it's $7 million on a $10 million claim, it might be emotionally much harder to move them down materially during the mediation day itself. Again, these might be things that you can explore in a pre-mediation private discussion with the mediator to try to work out what's best for that particular case. And then there are also some special considerations you might want to think about in a multi-party mediation. Do you need to communicate different messages to different groups? If, for example, you're mediating with different groups of insurers in an insurance tower, you might have to talk to each of them about different points. And if you are thinking about effectively a divide and conquer type strategy in a multi-party scenario, so I want to settle with one or two defendant groups first, having that locked down will actually give me more of a chance to focus on the others in the mediation, and I'll be able to bank some cash. Then that might also affect the way that you write your paper. You might think about writing a shorter general paper and more tailored individual papers for the individual groups. And again, because it's a mediation, you're not prevented from having those kinds of bilateral communications. So those are some high-level thoughts. Hopefully that's of some use.
Thanks, Donny. So what do you do as a mediator if one party's mediation paper is simply made up of legal arguments in their most inflammatory form?
So I think there are two things really that I would do before the mediation day even starts. One is a discussion with the other party to try to ensure that the aggravation factor doesn't derail the mediation. It's effectively a conciliatory role, trying to make sure that they are still on board, and we help them to understand that this is just something that needs to be worked through. And then there's also a discussion, I think, to be had with the person who wrote that paper, just to try and get them to understand that a more constructive approach is going to be needed on the day in the nicest possible way, of course, being respectful, but just saying that we are going to need to move past this. It might have been a form of catharsis. They've written it, it's off their back. And in a way, actually, if we can then start the mediation day with that same party adopting a more constructive tone, then that might get us off to the right start.
Okay, and what about too much information in a mediation paper? For example, what about including expert witness analyses regarding damages? Does this risk getting the mediation too bogged down with the details?
Sure, and I think potentially it can. You know, we've got to remember that the purpose of the mediation isn't to try the issues, and so there's no point in really debating each and every issue. Quite often that can lead to people getting sidetracked and getting too emotionally attached to a debate that may not matter that much. But equally, there are some cases where, especially if you're mediating early, some of these points need to be flushed out in order for each side to do its risk assessment fully. And so it is a bit of a judgment call as to what sort of material is likely to be helpful. Again, if parties aren't sure, it's always a good idea to have a conversation with the mediator before they finish drafting.
Okay. Thanks very much, Donny. That was very insightful. Thank you.
Super. So much. And that then brings us to the next segment, which is to do with preparing clients for mediation. And Amandeep, you were going to talk us through this a little bit. If it's all right, I might start by posing a question, which is, well, how important is it to prepare a client for mediation, and what can happen if they're not properly prepared?
Right. So I think it's an important question. I think it's important to prepare your clients for a mediation, especially if they're first-time litigants, especially if it's the first time they've been sued or they're suing, that they've never gone through the litigation process and they've never mediated before. And mediation can be viewed sort of as a detour or a pit stop as you're going down the road towards trial. They need to understand that a mediation is not a trial. The mediator is not a judge. That it's designed to be a collaborative effort among the parties with a neutral third party being the mediator to try to facilitate a resolution, a settlement for the benefit of the parties. They also need to understand what the day is going to look like. If it's a traditional ping-ponging with separate caucuses, they need to understand how the parties are going to be separated. There may be long periods of time where they don't see the other side, they don't see the mediator. But there's also potentially that you can go the full day, or you can be gone in a couple of hours, depending upon how the parties are making out and making progress towards a resolution. So they need to understand the flexible, not formatted nature of a mediation. It could be 2 hours, it could be 6 hours, it could settle, it could not settle. And they need to know that so they don't get frustrated with the mediation process. Because if they get frustrated with the mediation process, then they're not going to be have an open mind to mediation process. And if they're not having an open mind, then they're less likely to be open to settle the matter. And that can sort of taint their views of the other party, the mediation process, or the matter going forward. So you want to make sure litigants, especially first-time litigants who've never been through a mediation process, know what the role of a mediator is, how it functions, where it's taking place, the nature of the start and stops or the waiting and then hurrying up and making a decision. So they can be mentally prepared as to what the day will look like and how the actors in the mediation are going to behave.
Brilliant. Thanks for that, Amandeep. And so in a little more detail then, what do lawyers really need to discuss with clients? What sort of ground in detail do they need to cover when preparing them?
Right. So I think there's two main groups or categories. One is the actual process itself. I just touched upon it a little bit. And the other one is discussing with them resolution or potential resolution. In regards to the first step, the process, you want to understand that mediation is a non-binding process. It's a without prejudice process. And that what's discussed at a mediation is not going to make its way in front of a judge at a trial if you don't settle. So if you're suing someone and the defendant decides to get on top of a table and scream out loud, I breached the contract, I owe you $1 million, you can't then go to trial and say at a mediation, he said he owes me $1 million, right? And you got to realize that the mediator is an independent third party that's not going to be called as a witness at trial. They need to understand that oftentimes there's an initial meeting with the parties where the mediator goes through the process, perhaps summarizes the position of the parties. You may have an opportunity to speak as a party. You may want your lawyer to speak, and then you go out into breakout rooms. And you need to explain to them the process and the purpose of the breakout rooms is to keep the parties separated, to allow the mediator to talk privately or caucus privately with the parties to get their views on the case. You can share with the mediator privately things you don't want shared with the other side. You can tell the mediator you can share certain things with the other side, and know the role of the mediator is try to facilitate a discussion. I also like to tell my clients that the mediator's goal is to try to settle the case. And they're self-interested in trying to settle the case because he or she, as a mediator, the more cases they settle, the more likely they're going to get used again because they're going to be viewed as an effective mediator. And oftentimes, one tactic that mediators employ is they may come in and beat you up or beat your client up about their case and poke holes and stuff. And your client may say to you, he doesn't like our case, he doesn't understand our case, he's not supportive of our position. And oftentimes I tell clients that, look, he's beating you up to try to move you to a certain position, and he's going to the other side and probably beating them up as well and telling them what's wrong with their case to try to get them to move to a position. That's a tactic often mediators use. Another thing clients need to be aware of is that a mediator does not appreciate the full set of facts and issues because they only have what the counsel provide them in the mediation briefs. So they're not going to have the benefit, like at a trial, of having a judge with witnesses and all the documents and evidence. So if you have a mediator that may not share your point of view, they need to be aware that a mediation is not binding. If you don't settle, if you don't like what's being discussed, if you don't like what's being offered, you're not forced to take on what's being presented to you in regards to settlement discussions. So as long as they understand, going back to the first question, what the role of the mediation is, how it functions, how it could be, like I said, it could be 2 hours because you're not getting anywhere and you just move on to trial, or how you could be there till 5 o'clock and feel like you're getting close and you don't settle, or maybe you go into overtime and you go till 6, 7, 8 o'clock at night. I'm sure several of us had late night mediations. It's a very flexible approach, but it requires a buy-in of all parties. The second thing, and I guess the most important thing, is you need to discuss all the potential settlement options with your client. And what I like to do is I like to tell them that a mediation is an opportunity to stop the bleeding. And what I mean about that is you settle the case, no more legal fees, no more getting annoying emails from your lawyers or phone calls. You can either end the relationship with the party you're being a litigant with if you want to end it and move on. It's an opportunity to repair the relationship. Perhaps you have a business relationship or a personal relationship which has been sidetracked because of the dispute. And here's an opportunity to repair that to move forward. Eliminates the risk and uncertainty of going to trial. Remember, at a trial, you have a stranger, which is the judge, which is adjudicating your matter and making it a decision. At a mediation, you have the opportunity with the other side to control your own fate. And you can settle on any terms, conditions that you want. But once you get in front of a judge who walks into that courtroom, only have read the pleadings and the trial record, you're leaving fate into their hands. And judges are very smart and they're very fair, but sometimes judges may not share your point of view. And they may rule against you, even if you and or your lawyer think you have a slam dunk case. So what I like to do is I like to discuss settlement options. And settlement options are not confined to what's pled in the statement of claim or the statement of defense or counterclaim. You may be suing for money, you may be suing for property, but you don't need to settle on those terms. So oftentimes I like to push my clients on what's their motivation behind the litigation, like why are they suing or why are they defending? And in many circumstances, there are things beyond what's in the pleadings as to why the parties are involved in what they're doing. For example, if you have a family dispute, whether it's an estate matter, a property dispute among family members, perhaps there's an ego issue or one side feels jilted by the other side, or they feel embarrassed or shocked that their parents didn't put them in the will. Maybe there's a reputational matter at stake. In an employment matter where an employer is suing their former employee, you set up a competing business. Maybe that employer is suing the employee, maybe not necessarily because they think they can win, but they want to send a message to their competitors or their employees like, don't try this, because if you do, we'll sue you and we'll force you to spend legal money in court with lawyers, and it's not to your benefit. So oftentimes I ask my clients, I do this at the start of litigation, but also before mediation, what do you want to achieve? beyond what's in the pleadings? Is there something creative we can achieve? I also discuss what is the other side potentially looking at, because there's two sides to a settlement. You know, both sides have to want to dance, essentially is what I say. The defendant, for example, may not have money. They may be looking at bankruptcy, or they may be trying to buy time. Maybe they're not settling, even if it's a bad case, because they're trying to refinance, or maybe they're trying to leverage a situation where they can develop a future relationship with you. So I like exploring all potential settlement options, both what is traditional in regards to what's being claimed or defended against, but also what can be outside the box, i.e. in a defamation case, maybe it's a public apology or a public statement, things such as that. The reason why you want to discuss potential settlement options with your client before the mediation is you don't want a situation in which at a mediation, a settlement option is put forward by the mediator or by the other side, which you haven't discussed with your client. And now your client feels compelled or pressured into entering into a settlement or considering an option they haven't discussed with their accountant, they haven't discussed with their boss, they haven't discussed with their spouse or their partner. And what you don't want is that phone call or that email a day later, a week later, a month later, a year later as a litigator, where your client is expressing remorse or frustration or anger with you for entering into a settlement that they didn't want to enter into, or now that they've had an opportunity to think about it, they don't like. So you want to flesh these things out before you enter into mediation. The other thing often is when you're dealing with a company or a business, sometimes a representative is sent. So the boss isn't sent. And oftentimes that representative may have limited instructions as to what they can settle for. So if you're exploring all potential settlement options before the mediation, you want to provide enough ammunition for whoever that representative is to know the parameters of their instructions. Because you always run the risk that if there's an offer on the table and your representative says, well, my authority is only 50,000 or 100,000, I got to call the boss. If that boss is not available on the phone, you might not walk out of there with a settlement. And as we know, oftentimes mediation is the best chance to settle, because if you leave that mediation without a settlement at hand, the chances that you revisit those settlement discussions, what was discussed at that mediation, they go down tremendously. So that's what I sort of focus on with respect to preparing for a mediation in regards to what procedurally could happen, strategically what could happen, and have the client have an open mind as to what type of settlements they could look at or consider.
Great. Thanks so much for that, Amandeep. That was really helpful. And so if we turn that on its head, what happens if you're in a mediation and it becomes clear to you that your opponent hasn't properly prepared their client for the mediation? Does that give you problems or opportunities?
So it could be both. It depends on the situation. Oftentimes you'll know ahead of time how serious a party is in the mediation process. If it's a voluntary mediation, then both sides are motivated to settle, especially if it's early in the litigation. I think Mitchell touched on this. If it's mandatory, then it's something perhaps just going through the motions. But oftentimes when you get a mediation brief, if it's very flimsy, if it's not really argumentative, and then either the client has instructed their counsel, look, I don't have the money, don't invest the time and money in a mediation brief. Or you may have a situation where you have a counsel on the other side who doesn't want to settle the case because they want to keep dragging it on and making money, or perhaps they're so firm in their views as to their client's position that they don't want to settle. They think they'll win at trial. So it could become problematic if you have a party on the other side that is not prepared to entertain a settlement or settlement discussion, then the mediation is going to be quick. At the same time, if you have the other side which is not prepared because their lawyer is maybe not doing a good job, or maybe the other side doesn't appreciate their position, if you have a persuasive mediation brief, if you're able to effectively convey to your mediator what your position is in caucus or in your brief or in the joint session, and if you have a seasoned mediator or a retired judge, you want to leverage their influence, their power, their experience to perhaps, I don't know if bully is the right word, but put pressure on the other side to settle the case, right? The better your presentation is, the more impressive your view is, the more likely the mediator is going to side with you. And if you have another side which is wavering, they don't want to be involved in the litigation, their position may not be strong, or maybe the client wants to settle but the lawyer doesn't, that's an opportunity for that mediator to exert some pressure and influence on the other side to come to the table to negotiate. And maybe you get a resolution where otherwise perhaps you wouldn't have.
Great, super. Thanks so much for that, Amandeep. That was all really helpful. Great. Well, look, that I think broadly covers the 4 segments that we wanted to talk you through today. And what we thought we'd now have is an open Q&A session. I can see one question's already come in, which relates to situations where opposing counsel don't appear to be acting in good faith in the mediation process. And so examples of delivering materials late, not meeting undertakings, etc. And the question really is, do we have any advice for how to get them on board? Or is this a situation where the case just isn't well suited for mediation? I wondered, Mitch, whether you might want to take us through that.
Sure. I guess I'll approach it as a mediator, first of all. So one thing I do as a mediator is I hold pre-mediation conference calls. And one of the topics that I make sure I cover is there any documentation that one side needs from the other in order to make the mediation meaningful? And that gives us a chance, at least a few weeks prior to the mediation, to deal with the type of issue where somebody hasn't complied with undertakings. Is that an issue? Does it matter? How do we get them to comply? Could lead to private conversations afterwards with counsel to determine what the problem really is and whether it's really a problem and what's motivating it. So as counsel, you may want to give some thought to working with a mediator that does that type of, it doesn't have to be me, but has that kind of approach, or that you at least feel comfortable approaching them if they're not going to hold a pre-mediation call of any kind, to see if you can deal with that. I mean, and the other way I think of dealing with it, if your counsel is really just to pick up the phone, and you may be able to learn a lot by talking through these things. It can be email too, but I find that having a call will usually be more effective. Also, I think it's just important that you assume that it's really easy to assume that somebody's not acting in good faith. And that gets thrown around a lot in mediations. As a mediator, I'm constantly hearing during caucus that the other side's not here in good faith, whatever that means, because it's one of those elusive concepts. No one really knows exactly what it means. But it may just be that the other side just has a client that's just not cooperating, or they just don't have, they're just not organized. They don't have things together. Consider also potentially adjourning to a later date if you don't have what you need to have a meaningful mediation. Or maybe you start the mediation and you find out that the situation at hand is creating a stumbling block. It might not. And you could always agree to come back on another day. Remember, that can be virtually. I mean, you're probably doing it virtually to begin with, but it's not that big a time or cost commitment to have to break and then deal with it later. So that's how I'd approach it.
Great, thanks, Mitch.
Sorry, I had to. Thanks, Mitch, for that. So does anybody have any questions from the audience? You're welcome to unmute and show us your face. There's 27 of you. Come on, there must be one question out there. If not, I have a question for Amandeep. Okay, so pre-mediation calls, as far as I was aware, wasn't so popular in the past. How can pre-mediation calls help your session? What can it add?
There are some mediators that do it. I think it's an opportunity to, as a counsel, to expand on your position and advocate more to the mediator. To put something in their head, if there's something you want to emphasize, if there's something that you want to share privately with the mediator, but you don't want the mediator to share with the other side, perhaps there's an opportunity there to sort of put that in their mind before the mediation starts, especially if you think it's valuable. It's maybe an opportunity for you also to, if you have the other side mediation brief, if the mediator is open and receptive to it, and some mediators are and some mediators aren't, but to maybe challenge, nitpick, attack the other side's arguments, to have it in the mediator's mind. Just think of it, if you're going to trial and you have a judge there, if you're able to give the judge a preview of why the other side's argument should be undercut before you actually have the trial, it's to your advantage. If you have a mediator who's open to do so, perhaps say, look, I've read the briefs and let me expand on this. And look, I haven't produced this document in the materials yet, for maybe one of those tactical reasons why you want to hold it back for trial, but let the mediator know. And, you know, they say this, but they didn't mention this, and let me point you to this, or I'll forward you this. So there's an opportunity to sort of work the refs a little bit more, work the mediator more before the mediation.
And would you recommend that both sides do this? So say if the plaintiff has a pre-mediation call, is there any onus on the plaintiff to let the other side know that they've had this, to give them an opportunity to do the same? So there's an even keel of power between the sides.
I would expect the mediator to reach out to both parties if they're doing a sort of pre-mediation call. There may be a situation where a mediator calls you because they want clarity on something that's in your brief or the other side has raised. As a counsel, if a mediator calls me, I'm not necessarily asking him or her if she's called the other side. I leave it to them. But usually, from what I know, the mediator will schedule these with both parties before the mediation happens, if it's part of their general practice.
Yeah, absolutely. Thanks for that. Mitch, I would like to ask, there have been situations where, you know, mediation is really a client's day to have their say, whatever that may be. And often it is that they want to apologize and they want a mutual apology. How do clients get around it when the other side isn't willing to offer an apology? And at the end of the day, that's all that matters, you know, in the mediation. How do you encourage that? You're on mute.
Thank you. Sorry about that. So if the other side is not prepared to give an apology, but your client is insistent on one, yeah, you know, that's a tough one. You know, as a mediator, I think what I would do is, so I would have two approaches. As a mediator, I would try to find some other way to address the person's feelings other than, you know, through either an informal or formal apology. So a lot of, I mean, and how you do that is going to depend on the particular case and the particular person. But, you know, it happens all the time because it's rare in the areas in which I practice to find that someone's going to give an apology either as part of the terms of settlement or just during the course of mediation in the hopes of moving you towards settlement. Although I can tell you a great apology story where it actually happens if you want to hear it. If I'm counsel, though, what I've probably done ahead of time, long prior to the mediation, and then I've reminded the client prior to the mediation that it's unlikely they're going to receive an apology. And so we've worked through that. I've managed their expectations. I probably, as a mediator, I would do something similar, but I probably wouldn't have the opportunity to do that until the actual day of the mediation, and only if I heard about how important an apology really is. But going back as counsel, I think it's part of your job to make sure that the client understands what's likely to be achievable and what's not. And unfortunately, apologies, although they can be very powerful things and they can be wonderful settlement tools, they just, I don't find they're forthcoming. Apology acts notwithstanding, and mediation confidentiality notwithstanding, it's often difficult to come by. We also have to remember that even when an apology is offered, quite often they're risky because the person doing the apologizing may just do it wrong. It can actually cause more damage. You have to know how to apologize effectively, and not everyone has that skill. And so the story I was thinking of is I once had a defendant physician client involved in a commercial litigation matter. And he was being sued for an outstanding debt in relation to like a personal matter. And the plaintiff, during the course of the mediation, really wanted an apology, and it seemed to be driving the litigation, and it was an obstacle. Not getting one as an obstacle to settlement. And my client turned to me and said, I'm prepared to give an apology. I do feel sorry. I'm prepared to do that, not just to save myself some money potentially, but I feel badly for the person. And so in caucus, I asked the client to give me, let's do a run through. How are you going to apologize? Because this wasn't just going to be something in writing. We were going to go into the other room and this person was going to apologize. And this doctor had a wonderful bedside manner, I could tell, and gave what I thought was a really heartfelt, sincere, convincing apology. And so I said, okay, let's do it. And it did a wonderful job. But I could also see how that could have gone sideways in so many ways. So that here the plaintiff was getting what they wanted, but if you don't have an effective apologizer, for lack of a better word, it could actually cause more damage. But it's interesting because this does come up more often than one would think in commercial type cases, not just in employment, human rights, personal injury type cases.
Yeah. Would you advise if one of the parties sought out to make an apology, but you knew that the other room was perhaps not susceptible to that apology, would you advise them against it? And how would that ultimately make the client feel?
So as a mediator or as a lawyer or?
As a mediator.
As a mediator. Yeah, I wouldn't focus on the person. I think you're going to be pretty bad at giving this apology. You don't want to do that. So I think you just focus on something else like, I don't think this is really going to be the most effective way of bringing you to a resolution in this case. That did happen to me once. Somebody wanted to give an apology, but I could tell it was going to be a disaster. So I sort of talked them out of it without hurting their feelings, and we just moved on to something else. And they were able to address the opposing party's feelings in a different way. And quite often you can do that as long as you ask enough questions. I think that's important as a mediator.
Yeah, it's really tough. I mean, I've seen it in a mediation where even from a sense of cultural backgrounds where, there are certain cultures that are not willing to give apologies because especially if they are a particular, if they are men, it's more kind of egotistical kind of thing that, I am a stand-up person in my own community, I can't possibly apologize. But I did have a mediation where both parties were from the same cultural background and both were men. And there was I, the same color, but perhaps not the same background. And so I was stuck between the both of them thinking that how am I as a woman going to advance this mediation and help them both talk to each other? And it actually did come down to an apology. And it was incredible what things can actually happen in a room when the apology is out on the table. And whereas the other side doesn't necessarily have to speak the words, their efforts to actually try and settle the case after hearing the apology, speaks volumes. And so I'm always aware of how effective apologies can be in the mediations. Thank you for that. Donny,
yeah, I had a question for Amandeep, if I may. Sort of taking the narrative of the emotional client. If, as you're preparing your client for the mediation, they say to you, "Look, I just can't stand to be in the same room as the other person," and you want me to go to this mediation because you say it's mandatory in Ontario, fine, but I absolutely don't want anything to do with them. If you could by any chance set the temperature in their room to be uncomfortable and give them lousy sandwiches, that would be ideal. What do you do then from that perspective?
Well, I try to encourage them. I would try to encourage them to be at least in that initial meeting, because once you get into breakout rooms, the likelihood is the parties don't cross paths. That initial breakout meeting, I would see if I can get the client to agree to be there, and try to support them, saying, I'm going to be present in the room with you to act as a buffer, that to expect that the other side is going to be respectful. There's a mediator in that room. Because if this matter doesn't settle and you go to trial, the likelihood is you're going to have to be in the same courtroom with that individual? Are you going to be testifying on the stand in front of a judge and being cross-examined with that other party on the other side of the table? And it's tough, I understand, especially in certain types of allegations and causes of actions. But if they can, develop or muster the strength and the fortitude to go through that process, I think it's important. I think it also helps them psychologically if they can do that and then move forward. But if it's something that they can't absolutely do, then I likely, reach out to the mediator first and say, look, here's a situation. Can we just sort of start off in breakout rooms as opposed to be in one room itself? Because I rather start in breakout rooms as opposed to me sit with the other side when my client's not beside me in another room. Because that's going to be viewed and interpreted by the other side likely as a sign of weakness, or the client's not going to be wanting to go to trial. It's scared, and they could be all illegitimate, improper reasons. It could be other reasons why. It could be cultural, for example. So I have to be sensitive to those factors. So I listen out to the client to understand the reason why. But if it's my opinion, something where I think they should, for their benefit and for the benefit of the mediation, be present to hear what the mediator is going to say in the presence of the other side. Perhaps have an opportunity to speak. I would encourage it, but I'm not going to force it upon my client.
Great, super, thanks. And I had one as well for Mitch, if I could get it in before we were out of time, which is in a dispute with a corporate on one side, and if they send a representative, it's quite normal for the mediator to ask that any representatives have proper settlement authority coming into the mediation. If having asked for that, when you are then in the mediation, you very quickly discover that they say, actually, I have very limited settlement authority. I only have authority to repeat my past offer, and my boss is off golfing today. Where does that leave you?
Yeah, that's a tough one, and it comes up so often. And it's incredibly frustrating because it's probably likely that the lawyer who's representing the corporation is secretly frustrated and doesn't have the ability, although they may have tried to ensure that they have somebody there available to give instructions, but they're unable to do it. Again, it really, I think, depends on the case. If there's limited authority, I think it's something that should be expressed to the other side by the mediator, or by the mediator with the lawyer for the corporation, so that the other side is very clear on what can be achieved that day and what cannot. It avoids bad feelings and allegations of bad faith, later on. But I have seen situations, though, where it doesn't matter because the case ends up settling within the authority that was available in any event. So it's tough to know when to, when to rock the boat, so to speak, and not. So I think the mediator has to use common sense to determine whether or not there's a possibility the case will settle within the settlement authority that is possible, assuming and whether the mediation should proceed or whether you recommend adjourning it. But these are case-by-case type scenarios that I think mediators deal with on a daily basis, and over time they gain the experience to know what to do in any particular situation. But as counsel, it's really important that we explain to our clients how vital it is that they come with full authority, or that there's somebody with higher authority available. Otherwise, consider rearranging the mediation to another date, because otherwise it could just be a colossal waste of time and money. The other side may perfectly understand because they want it to settle, hopefully. Yeah.
Thanks, Mitch. I want to thank all the panelists, Amandeep, Mitch, Donnie. It's really, really insightful, very useful conversation, and thanks for the materials that have been submitted as well. I hope that our attendees find those helpful. Just a quick reminder that today's program may be eligible for 1 hour of substantive CPD hours. I'm hoping that you will be awarded with EDI and professionalism hours, and we will let you know as soon as we hear back from the Law Society. Also a reminder that this is only part 1, more exciting things to come in part 2, which will be held on the 18th of November at 9:30. It's called the Mediation Day. And we're going to have wonderful Nadia Zaman and Gary Furlong helping us on our panel alongside Donnie and myself. So if you can join us, please do so. In the meantime, I wish you all a wonderful afternoon, and thank you again for coming.
Thanks so much, everyone.
Thank you.
Thanks for having me. Thanks for your discussion. Very helpful.
Thanks, Mitch.